Thank you very much. My name is Michał Wawrycznczak. I'm a PhD candidate at University of Bologna and Adam Mickiewicz University. And I would like to thank, of course, Judita for the invitation, but also for a very convenient placement on the agenda, because all three presentations have been directly linked to my presentation. And I even managed to set a trap for Rosa to introduce my topic into the discussion even before my 20 minutes. And of course, I already apologize for extending the time that I was allocated, even though I only started, but I know that I will not make it in time. So I'm very sorry. Just tell me when I have to definitely stop, and we will continue going on with that. So what I prepared today is a topic which is it's going to be jumping up and down in the volume. I'm sorry, this will work like this. What I prepared today is a topic which is very tricky, because this is about the understanding on how we perceive rule of law, because this is a fundamental issue that we have. We have the rule of law crisis in European Union. But what does it really mean that we have the rule of law crisis in European Union? And this is a problem because we are essentially operating within two different concepts. We have Rechtsstaat, which is very popular, or I would say predominantly popular within the European Union, where we have a codification of a detailed constitution, more or less detailed. I will go into that in a later part of the presentation. But we also have rule of law, which comes from the Anglo-Saxon tradition, where the constitution as a present document may be absent in general, but all in all, we have a crucial participation of the judiciary in a process of creating the law. So opposing to the Rechtsstaat, where the judiciary is essentially obligated to interpret, analyze, and provide the explanation of the legal principle which is set by the politicians, in the rule of law tradition countries, it is exactly the opposite, where the judges have to take the burden on setting the limits on what is allowed and what is not allowed in many, many instances. So what I want to analyze is the evolution of the scope of regulating European cooperation in criminal matters. So thank you for bringing up Meloni, but we have to go way further beyond that. Meloni was just the beginning, and we want to go to the contemporary judgments. So I would say, regarding your presentation as well, when you have also on the very last slide, I believe, introduced the German Federal Constitutional Court, there is way more than that. If you remember the Selmer case, the LM case, which was the very first crucial judgments in the European arrest warrant, European cooperation in criminal matters, the Court of Justice established a test. And that test was essentially thrown out the window by the German Constitutional Court and also by the Dutch Constitutional Court, when they said that we are sorry, but this test is completely unworkable, because it obligates the judges to ask the judge from a compromised rule of law country to ask, okay, we are sorry, we know, of course, that you are subject to disciplinary liability if you say that you will apply EU law, but will you apply EU law? And they said, we cannot trust. Of course, we can trust that the judge will take the decision with their hearts, and we believe that there are good judges in Poland, and so on and so forth. But this is just asking somebody to essentially incriminate themselves in terms of disciplinary regime proceedings, just so they can perform their function properly, and we are not going to do that. And we, on principle, we will withhold the European cooperation with Poland in criminal matters, which actually occurred with Netherlands, who suspended that cooperation entirely. It is a precedent because it has never happened before, even though the Article 7, paragraph 1 procedure has not been activated and triggered towards Poland, what only would allow for such a suspension. So this is the first element, and that evolution of the scope of the regulating has came to the mutual trust judgments, actually. And this is very interesting, and I could talk on this 30 minutes alone, but I have 20 minutes for the total time. So maybe next time we will figure it out. The second part is the issue of the rule of law, which is derived from Article 2 TU. So this is the introduction of the new generation of the mutual trust judgments by the European Court, Court of Justice of European Union. And the third question is the nature of the constitutionalism, both in national and community terms. So again, the rule of law and Rechtsstaat notions are not the same. There are differences. I will go to that in a second. We will have also today the topic of the Copenhagen dilemma. Welcome again, Nicola's speech on that. We will have to talk a little bit about the sovereignty and whether we actually seize or cede that sovereignty or we are losing it, and that process is important in the terms of the rule of law crisis as well. Then I would like to introduce you to the varieties of constitutionalism theory. So this is what you implemented in your topic, the constitutional plurality. But I would like to tell you how that plurality actually plays out. And the final part, is the EU and CJEU rule of law oriented or rather Rechtsstaat oriented, because this is crucial for the analysis on what is the way forward for us and why that cooperation is perhaps not working currently as it should. So let's go to rule of law versus Rechtsstaat. If you look at the rule of law, I'm sorry, I will use that chart to leave it because my notes are useless now since you gave 3 great presentations and I can just work on them. If you have the rule of law, we have the so-called dual conception of power. This is Palombella's work. He's one of the best researchers on the topic, and he was already analyzing it from the Magna Carta times on the UK example, how that played out. Because if we are talking about the rule of law, we are essentially talking about that a dual conception of power, but 2 tensions. So we have 2 spheres, jurisdictio versus gubernaculum. So we have the judicial powers that are supposed to protect what is private, what belongs not to the monarch, not to the state, but rather to the people. And jurisdictio is supposed to protect the monarch, not the people. It is supposed to protect the monarch from engaging illegally on what is private. So this is a very peculiar setting in which we have the courts which are not meant to protect the people from the power, from the state, but rather the state from exceeding the powers of the state. So this is essentially Magna Carta, and then we develop further on it. And gubernaculum, so what is public, what belongs to the monarch or what belongs to the state later on. Modern take and the modern concepts that we have in politology, so checks and balances systems. But checks and balances really only works in the rule of law countries and not in the Rechtsstaat countries, because there is not the tension that exists in the rule of law. That tension is horizontal. That means that the jurisdictio and gubernaculum, they are both equal. So this is what I was asking you in my question. When we have the domestic courts, let it be the highest instances of the courts on the domestic level, within the European Union, are they actually in a horizontal relation to the Court of Justice? Or is this a vertical relation where we have those courts who are the highest instances, so again, a vertical relation domestically speaking, and then internationally on a community level, is this again a horizontal take or again a vertical take? So in the rule of law conception, we only have horizontal tension. Of course, there are different instances within the jurisdictio part, but the judicial highest body is equal to the gubernaculum, so to the ruler in that instance, because they have to have the means to effectively protect the state from the state. So this is also very peculiar because, as I said before, we have the law of the precedent that is reigning in the rule of law states. So that means that the catalog of the sources of law is open. It's not closed like within the constitutional countries where the constitutional says, for example, the Polish constitution says the sources of law is this, and this, right? So anything else than this is not publicly binding, cannot be a subject to a norm that bounds the citizen. It may bound the internal organization. So for example, if the office has internal regulation, it will only bound in the internal sphere and not the external, in a sense that only people who work for that office will have to adhere to that norms that are set there in this regulation, but not people from the outside. So in that rule of law countries' legal systems, we usually have an open-ended sources of law. So new judgments may establish new principles to which people have to adhere. It's exactly the same as the explanation of the Constitution. Everybody knows Miranda rights. In the US Constitution, you do not have anywhere written down before that judgment that you have to invoke the Miranda rights, and anything you say will be used against you in the court, and so on and so forth. This is a purely creation of the jurisdictional order. Where you have the Rechtsstaat, we basically operate on the Montesquieu tripartite of power theory. So this is why the rule of law crisis is actually not a perfectly fit, I would say, description of what is happening in European Union. If you want to discuss the processes that are occurring, we would rather have to refer to the tripartite of powers crisis, because it means that the political power tries to take a bit of the more powers of the judicial sphere, actually. So what was happening in Poland, it was not that horizontal tension between the jurisdictio and gubernaculum that we had, but it was rather a legislative part of the three powers that was trying to interfere with the judicial one. We don't have that traditional system of the checks and balances that we have in the rule of law countries. We rather have a very peculiar setting in which every one of the three divisions have to control each other, but none of them is equally equipped actually to stop the other one. So they are meant to delegate the competences to each other, right? But except for the fact that they cannot go beyond that, they can do nothing in order to stop it, whereas in the rule of law countries, you have the courts that will just put the end to certain legislative initiatives, for example, or any other executive acts, and they will say this is the end. Yes, you can do that in the Rechtsstaat if you have the constitutional court that can say, for example, that the proposed norms are violating the constitutional principles, but this is not on the exactly same level, because this again comes from the law that was established before by the legislature. Because if it is derived from the constitution that is described by the law, it means that it is not a creation of the judicial sphere, that you cannot pass that bill because this is contrary to the provisions of the constitution. It is just a matter of the application of the law that was already established before by the legislature. So this is an important difference that we have here. Usually, it is a constitutional state with no horizontal tensions. If anything occurs in Poland, for example, this is rather a vertical one. So this is a problem of the courts that have to apply the law that they would disregard, but this is a matter of the law coming from the superior body of the state. So, as I said again, because the laws have to interpret the law that is given to them and they do not create the law themselves, they may provide an explanation of that law, but it is only within the limits of the wording of the principles, for example. This is completely different to the rule of law reality. And again, due to the above, the methodological order that we have, the Constitution lists the close catalog of the sources of law. So this is an entirely different setting. And if we go now to the Copenhagen dilemma, so this is what you said, but not what you named, but when we have the states that want to participate in the community life, that want to adhere to the European Union, they have to fulfill a certain set of principles, right? So I'm not going to repeat what Nicola said. You just had to listen to this and you already know everything. But the problem is that the European Union has the tools to execute the amount of sovereignty that has to be ceded to the European Union prior to the accession. So you have to make this, and this change if you want to be a part of us. And there is no discussion on it except for the negotiations, but they come for the scope. There are some criteria that are stiff and you cannot negotiate on them. but you have to change your law if you want to be a part of us. So again, what you were talking in the context of Slovakia as well, and that dialogue that goes on, how much of our sovereignty we have to see. But the problem occurs when you have the changes that may be contrary to what is the accepted EU policy in the terms of, for example, organization on the judiciary. So again, we are coming back to the rule of law issues with the Polish rule of law issues. When you have the Court of Justice of European Union and European Union political bodies saying, no, you cannot do that because this is contrary to the values that are enshrined in Article 2 or Article 19 or Article 47 of the Charter, and you can go on and you can continue with the list of the infringements that occur. But the problem is that you don't have any means by the treaties in order to execute a reversal of the changes that are implemented, because the states, they are sovereign in a lot of ways. I wanted to ask you, but I decided that this I will cover, because the problem is that when you have criminal law system, for example, I'm researching in the criminal procedures, so this is naturally my topic. When it comes to the civil law, the scope of EU intervention is much broader. When you have the criminal law, you only have the Article 82 and 83 of the TFEU, and only within those spheres. So when it comes to the criminal law, only harmonization instruments and standards of the minimum norms when it comes to the procedural dimension, or essentially transport the crimes that are enlisted in Article 83. And this is the end of it. Everything else is the power of the state, a sovereign decision of the state. So when you have this issue, you cannot essentially enforce the state to retrieve these changes to the state that was before. That's why CJEU started with Meloni and said you have to disregard the national standards because this is EU law and this is the instrument that has to be applied. End of the story. Filling up what you have said in your presentation, why this happens? Because of the mutual trust. We have to trust each other that our procedures are observant to the principles that we share together, that we adhere to in Article 2. But the problem occurs when we don't have that mutual trust anymore. Because what is essentially a mutual trust? It started as a tool to enforce mutual recognition. So in the Meloni case, the court was still saying, but mutual trust is crucial so that instrument of European arrest warrant, that essential pinnacle of the cooperation, can go on. Because if we don't have that trust, if we have to verify everything, including the in absentia regulations that were present in Italy, then we will actually have the issue of no cooperation, because maybe there will be a trust, but there will be no recognition because we don't have that standard. We have that standard in our country and you don't, so I cannot recognize this. But in the later cases, especially in Republica, which in my opinion is the most important one right now, the non-regression principle that was established there, the court said, no. Mutual trust is not about recognition anymore. Mutual trust now is about the recognition of values. It's about the Article 2. It's about the rule of law. It's about the foundations. So it is not about enabling the cooperation anymore. It's about enforcing the political and judicial legal reality that you have, that you had the moment you were making an accession, and you have to adjust to the European standards now. You cannot have lower standard that you had when we accepted you, and non-regression principle serves as that checks and balances operation. But this is an operational clause that was created only recently. For a few years we have this. We didn't have that before, and this is the importance of the Court of Justice, assuming, again, that's why I was asking you if this is horizontal or vertical. The Court of Justice is essentially assuming the role of jurisdictio from the Anglo-Saxon tradition, instead of taking the traditional Montesquieu tripartite of powers division, the role that they have, because they created a new operational clause on the premise of the law that was interpreted before, of course, but it was not found there then, because there was no necessity to do that in order to prevent what was happening. Another example may be the conditionality mechanism. So this is just purely about the money, when the court decided that, well, maybe the money is regulated in a different article, but, you know, we can do that. Now it's EU law, of course. we will find a way to explain that you have to obey to the rule of law in order to receive the money from the restoration fund, because this is different than what is required by the EU law to give you as the part of your subvention. So this is actually not falling into the Article 7, paragraph 1, but we will use the other articles to explain this, so we can create a precedent on withholding the payments again. So a hot take, as I said, is this, in your opinion, and I would like to know what you think, is this actually a creation of the rule of law setting in the Rechtsstaat countries then, or is it still a very peculiar, exceeding the scope of the Montesquieu tripartite of power division, but still a Rechtsstaat setting? Because okay, because as you take a look, we have the constitutional plurality in the European Union, even more what you said. We have three types of constitutionalisms. Of course, there are subgroups within these major groups, but it's easiest to categorize them like this. So it's us, the post-communists, who fear the external presence of a body that will impose the rule of us. So for us, the sovereignty understood as the will of the nation is the most important one. This is the foundation myth of our constitution. We believe that what comes from the people has to be the law. And this is also reflected in how the competences of our constitutional courts are shaped. We don't have the open-ended constitution as a legal entity operating. We are operating within the constitutional doctrine of the political questions as well. So this is not only a matter of a legal interest. Of course, it is a legal rather than political entity, but we still have that political interference, and we still have some scope of powers constitutionally wise that are reserved to the parliament. And this is again the problem that we have had with the rule, and we still have with the rule of law in Poland, where we have that parliamentary intervention within the constitution and revoking the shape of the constitutional bodies that we have had established in 97 to the new order. Because what was the explanation? Because we were elected by the people, we have been given a mandate, so we can execute this, because what the people want, they trusted us to do it, so we have to do it. And this is very short, because of course I don't have that much time, and I'm probably running very low on what is allocated to me, but this is contrary to the post-fascist constitutionalism. In those states, you actually have constitution as the legal entity rather than a political one, because the founding myth is completely different. It is not the fear of the external intervention, but rather the fear of the internal intervention. It is the fear of the people that can be good but will go bad if things go bad. Contrary to what we have in the post-communist group and the evolutionary constitutionalisms, you even have a permitted possibility to ban anti-democratic parties. So you can enforce, you can limit the scope of political participation constitutionally wise. You can limit that freedom that in theory should be unlimited because it is a fundamental human rights, right? But this is different because those states experienced actually the tragedies that they have had, the Nazi Germany, the fascist Italy, the Spain, Portugal, Greece, they all have had those experiences coming internally and not externally like we have had with the Soviet Union. So for them, they have to find a way in order to limit that sovereignty of the nation. And that is why the constitutional courts in those states have much wider scope of powers than the ones in the post-communist parties, post-communist ones. In some of those states, the president is not even elected by the people, but rather by the parliament. So this is another checks and balances system that is completely different to the post-communist one. When you have the evolutionary constitutionalism group, so you have essentially Sweden. I think I made a mistake. It was not Norway, but it was Denmark. I sent you the wrong version. My apologies. This is Denmark and not Norway. And UK is no longer in EU, but it's still valid for the purposes of this conversation. in UK, you don't have a constitution. In Sweden and in Denmark, you do. But they are very not positive in a way that the post-fascist and post-communist constitutions are. Because the post-communism constitutions are very detailed, are very long. They try to regulate every sphere possibly happening and try to provide you a detailed description on what you have to do. The post-fascist one, they make you an open-ended possibilities to interfere in order to protect the state, again, from the state, from the people that create this state. And with the evolutionary constitutionalism, you have a constitution as a political entity rather than a legal one. Because there is a political doctrine present as well. Of course, every question, just like in the post-fascist one, is deemed a legal question and can be referred to the court as the political constitution, as the constitutional question, whether a legal or a political one. But it's still a short, undetailed constitution, because evolutionary constitutionalism, those states are not coming either from the fear of the external intervention. When we are talking about Denmark, okay, there was a very brief period in the 20th century where they have been submitted, and Sweden, as the collaborators, they didn't really have to be bound so much by the Nazi legislation. So we don't have that much of that fear of external intervention as it comes for the rest of the post-fascist states, although they were not purely fascist states. So, for example, Belgium or Netherlands, although they were not post-fascist in a sense, they still have that understanding of constitution and that scope of the constitutional powers granted to the constitutional court, for example. Those states, UK, have won the World War II, were not submitted by any country for, well, since the Roman Empire, basically. So they didn't have to fear that. They could evolve, and they did not have the fear of the people. So the external and internal fears were not present. So they believe in that evolution in a crown in parliament, where they have evolved. They still are in the monarchy system, but they have evolved from that. So for them, that scope of powers and scope of checks and balances is completely different. It's the closest to the rule of law that we have actually. For UK is clearly rule of law, and Sweden and Denmark, it's a little bit of Rechtsstaat and a little bit of rule of law. But again, we have that crucial differences actually that impact the way that the European Union functions as well. So going basically to the end now, because I'm already way past, I'm quite sure of that. You are very kind, you don't say anything, but that is what it is. We have vital and present differences in the existing EU legal orders. We have different cultures. We have the civil law and rule of law. We have the broad powers to create, civil law-based Rechtsstaat. I should have had there is again a mistake. I'm sorry. Too much going on in the past days, but you have the tripartite of power separation as well going on, and this is crucially because you have the duality of powers or the tripartite of powers, and within the European Union, if you have that horizontal tension between the states and the Court of Justice, is it really the horizontal tension that we are talking about in terms of the rule of law? Because those states, they are not the EU legislators who interpret the EU law. They are actually just implementing the law that is taken by a different body than the states themselves. They don't enact EU law in the sense that they don't create it. So the question is, are they horizontal with those states? And between each other, of course they are, but are they horizontal with CJEU and with the EU Parliament or Commission, for example, or is it again a vertical tension? And if it is a vertical tension, is it again a rule of law proper conception, when horizontally speaking, you should have all EU bodies on a horizontal level and only vertical levels? So this is the first issue that we have. And again, the question is, and let's go into the social details right now, and again, coming to your presentation and to your presentation, to your slightly less, when you have that issue with the states, the question is that foundational myth still present in the nations that have created those constitutions. Those societies that we have now, is the law adjusting properly to the societies that we have, to their expectations and to their demands, or not? Is the younger generation or the majority of the society currently more inclined towards the EU law and EU obedience rather than the domestic national sovereignty and that fear of the external intervention? If you take a look at that chart that you have had before, if you have the post-fascist states, their constitutional orders are actually what rules the EU understanding of the rule of law, in a sense. It is their perception, and they comply mostly, except for the disobedience of the highest courts, but they comply mostly with the EU law, and this is the post-communist states that actually have this trouble to give up the part of the sovereignty because the constitution was created in a way that was meant to preserve the maximum possible amount of that sovereignty. So this is why we have the constitutional issues between the post-Soviet states, post-communist states, and the EU law, because our constitutions are not fully coherent with what EU expects. So now the question is it time for a change with some or all of those states? Do we have to amend it, or is there a way to work around it? So, well, that's that much from me. The question, the last one, was for you. I hope you will fix it with the national sovereignty and how much we have to give it away and how to give it away. I would like to thank you once again for your patience, of course, very long, but thank you very much. And I hope you will have very nice remarks because I'm really inclined to discuss this.